Good afternoon. A lot prettier weather out there now than we had this morning to start with, that's for certain. Call the first case, please.
Conserv Equipment Leasing, LLC versus Schubert Enterprise, LLC et al.
We'll hear from the appellant.
Good afternoon. May it please the court. Josh Jenkins from the Rutherford County Bar here for the appellants. Schubert, Jackie Schubert individually, and as doing business as Schubert Enterprises LLC. I'd like to reserve 5 minutes if possible for rebuttal.
That'll be fine.
May it please the court. In the situation before the court, there's no denying at the underlying state trial court level that our answer was filed delayed. We did, on behalf of Schubert Enterprises, filed an answer approximately 3 months and 2 weeks after they were first served with the lawsuit. The record shows on the date that they were served, the underlying collateral securing the leases were also repossessed at that same time on February 10th of the same year. Approximately 3 months, 2 weeks went by after my firm had been retained by Schubert Enterprises and Jackie Schubert, that we contacted opposing counsel, provided a copy of the answer, the verified answer. This was the Friday before the Monday morning hearing, and we also fax filed that verified answer with the clerk. Upon the hearing that morning, the clerk notified me as counsel that they needed the original to be filed because it contained a verification. The fax filing wasn't sufficient. So the answer was fax filed in person with the clerk about 30 minutes prior to the hearing. Opposing counsel had that answer the Friday before that hearing. Although procedurally, admittedly, it's a little abnormal of how we got here, this appeal stems from the court's denial of a motion to set aside the default judgment that was granted. And that would be the March order, which simply just re-denied the motion to set aside. As the court probably could see in the statement of evidence, there was an issue with service of the original order, which resulted in a delay in the counsel before the court being notified that the order had then been made final. And so it took some time to get to the appealable order, which brings us here before the court. As the court's well aware, Tennessee courts are to construe motions to set aside liberally in preference for a trial on the merits. I believe that is the case here.
What reason did the trial judge give you for not setting aside?
For not setting it aside, Judge? Mm-hmm. The order says no excusable neglect. We didn't have a court reporter. The counsel before the court does not recall a specific reason why other than no excusable neglect. It was a fairly short Zoom hearing, that original one. And then the second time, the order that we have now appealed, there really was no consideration of the motion to set aside itself as more of a procedural issue because of that lack of notice that was provided. The original order, there was no certificate of service, and so I never received a copy once it had been submitted to the court and didn't find out it had actually been signed by the judge until day 32 of that 30-day period. So that's why the procedural issues were a little bit different. But there was no factual finding, and I've set that forth in my brief. There really was no factual findings by the court other than no excusable neglect.
Okay.
I would submit to the court that our case is not unlike the Abercrombie case that I've cited in my brief. It is an unpublished decision, but the site is 2003 10 App Lexus 709. And the facts are very similar, albeit procedurally, it's a little different than the case before the court in that the Court of Appeals was not considering an appeal of a motion to set aside in that case. Instead, trial counsel appealed directly from the granting of that motion for default. Factually, though, they're very similar to the case before the court. In that case, Mr. Abercrombie was served, and nothing happened for over 6 months. There was no answer, there was no motions, nothing happened. He was served, and then nothing happened on either side. Mr. Abercrombie, a little bit different than the case before the court, then did file a motion to dismiss, but again, no action was taken by the court or by either side for a period of another 4 months. So at this point, we're 10 months into the proceeding at this trial court level. After that 4-month period, First Union and the plaintiff did file a motion for default against Mr. Abercrombie, and out of an abundance of caution, it appears Mr. Abercrombie, 3 days prior to the hearing, filed an answer. I went back and made note. The court, in that opinion, said the hearing took place on May 7th of 2001. May 7th actually happened to be a Monday, as in the case here, and Mr. Abercrombie filed his answer 3 days before. Court doesn't say whether it's 3 judicial days or just 3 actual calendar days, but 3 days before. I would submit to the court it's not terribly unlike this case where opposing counsel was provided with a copy of the answer on the Friday before the Monday hearing, and it was fax filed with the court clerk. The court did note, while it felt like, and the Court of Appeals felt like it could rest simply on the fact that Mr. Abercrombie had filed the motion to dismiss, it went on to note that in addition, the answer was filed, and at the time the trial court granted the motion. So the trial court went ahead and granted the motion for default in the face of an answer having been filed prior to the hearing. Like Mr. Abercrombie, Jackie Schubert and Schubert Enterprises had filed an answer, had presented their defenses, affirmative defenses, and responded to the complaint. It was a verified answer under oath, and we believe that that was sufficient for the court to not grant the default, and that was a sufficient reason for the court to grant the motion to set aside that we filed. Mr. Schubert's delay, in our opinion, was excusable. He attempted to resolve it. He contacted other counsel, none of which ever entered a notice of appearance, but you'll see in the record, pursuant to Mr. Schubert's affidavit, none of them told him that an answer had to be filed. One attorney did say, you need to go to the court, but no hearing took place. He was relying on the advice of these other attorneys. I would submit that there's only a 3-month delay, a little 3-month and 2-week delay from the time Mr. Schubert was served and the collateral repossessed in the filing of this answer. That would be no prejudice to the appellee Conserv Equipment Leasing, because they had the collateral now in their possession for which they were suing on the underlying rental agreements and notes. There was no prejudice to the decrease in value to the equipment. There's no prejudice for the equipment possibly being sold off or destroyed or hurt in any way. This is simply an attempt to collect an alleged debt owed, and mere passage of time is not sufficient enough for the court to deny the motion to set aside.
What was
Yes,
the
Judge.
excusable, I mean, do you agree or disagree that you have to start out with whether or not there was excusable neglect?
I believe that is an element that the court has to consider, Judge.
All right, so what was the specific, and I've always loved that term, excusable neglect. I mean,
Yes,
you're
sir.
neglect, but but anyway.
Understood.
Yeah, what was the excusable neglect argued to the trial court?
Your Honor, essentially exactly what I put forth in my brief and what's before the court now. Mr. Schubert was attempting to take care of this by reaching out to counsel, and his affidavit and the representation was to the court. Well, these folks that he spoke to, none entered a notice of appearance, and no one told him exactly what he needed to do. The one time he was instructed to go to the courthouse, he did, and the hearing had been moved. And that was right about the time contact was made with my office, and we were then reached out, and we went through the process of being retained. I'm located in Rutherford County. My client's in Crossville, so we got together and we filed an answer and got it to opposing counsel as quickly as we could within those few weeks of time of him contacting our office and being retained and filing the answer. So our position would be the excusable neglect was he was taking the steps to do it. Frankly, I don't know that his position is, and the testimony in the affidavit is, he just was never advised the proper thing to do. Lastly, very quickly, with my 1 minute remaining, I pointed out in my brief, and I'd like to point out that the reliance on the state XRO Looper case, I would proposed to the court is misplaced. It is a different type of case factually and procedurally. In that case, it's a unique situation because it was an ouster case involving Mr. Looper, which underlying you've got public policy considerations and things like that because they're seeking to remove someone from a public office that has violated their duty of public office. In that case, the statute controlled the timing for which he had to file his answers to these complaints because the statute set out a specific 20-day time period, and the Supreme Court had said in the prior case that the statute controls the timing. So you get 20 days instead of our normal 30 days under the rules of civil procedure. Mr. Looper, in that case, fired his counsel not long before a hearing on a motion for default and a combination of a motion for summary judgment. And in that case, the attorney showed up, filed the answer 10 minutes before the 9 o'clock hearing, and actually finally served opposing counsel at the time of the hearing and during the hearing with their pleadings. I would submit to the court that's different in this case, where we had filed and served approximately 3 days before the hearing, the Friday before that Monday hearing.
You have your, you have your time for rebuttal. We'll hear from the appellee.
Good afternoon.
Good afternoon.
Beth Rogers for Appellee Conserv Equipment Leasing, LLC. I think that the facts are largely not disputed, but I'll go through a few of them. We filed suit against Schubert Enterprises and Jackie Schubert on certain equipment lease contracts, notes, and a guarantee. The plaintiffs, we sent a demand letter to the defendants prior to filing suit, and after sending that letter, we were contacted by an attorney, Steve Daniels, who responded to the demand letter. We then filed the complaint on January 25th, 2021. The defendants were served with the complaint on February 10th of 2021. The summons, of course, stated that the defendants had 30 days to file an answer to the complaint. The same day that the defendants were served on February 10th of 2021, we were contacted by an attorney, Dustin Smith, who acknowledged that the defendants had been served and made a settlement offer. The settlement offer was rejected, and we were contacted by another attorney for the defendants, Christy Hornsby, who I had a phone conversation with on February 17th of 2021, where we discussed the pending lawsuit. So despite having engaged 3 separate attorneys, the defendants failed to file any timely answer or other response to the complaint until May 24th, 2021, just minutes before the hearing on plaintiff's motion for default judgment. While the defendants claim in the affidavit of Mr. Schubert that he hired Steve Daniels and then consulted with an attorney that was the wife of an acquaintance of mine who told Mr. Schubert he needed to appear at the hearing previously set for April 26, 2021, defendants don't account for the hiring of Dustin Smith with the firm of Colson, Maxwell, and Smith, nor did Mr. Schubert state in his affidavit whether Mr. Smith had advised him to file an answer. The reasons why these prior attorneys who had involvement and did, legal work on behalf of the Schuberts were not retained by the defendants is not stated in the affidavit. So I think that, the affidavit is somewhat specious in that it doesn't lay out all of the facts preceding the failure to file a timely answer. Prior to the hearing on the default judgment, I received a call from Mary Beth Hagan stating that her firm was in the process of being retained and requesting a continuance of the default hearing, to which we agreed. However, we made it clear that we were not waiving the right to proceed with the default judgment against the defendants. Further, Your Honors, there is no evidence in the record justifying or explaining the more than 3-week delay between when the defendants first spoke to their current counsel on April 30th of 2021, and the actual filing of an answer in this matter on May 24th of 2021.
I asked you the same questions I asked counsel. What was the reason that the trial court refused to set aside the judgment of default?
Your Honor, that was based on the failure to show excusable neglect. And, I think that the defendant's conduct was willful in failing to file a timely answer. They obviously had consulted with at least 3 attorneys prior to their current counsel. They had the summons. There's no dispute that they were served with the summons and complaint and with the motion for default that's even set forth in Mr. Schubert's affidavit. And the assertions in his affidavit that he was ignorant of the law, he didn't understand, or he wasn't advised that he needed to file an answer have been rejected by numerous Court of Appeals decisions of this court, including in the Looper case and the McBride case, which we have cited in our briefs. And
Now,
as well
you have just given me those answers, but what has the trial court presented in their record, in their order, as to their reasoning for making that decision?
The trial court order says that the motion to dismiss was denied because the defendants did not show excusable neglect. That's what is stated in the trial court's order.
So the trial court didn't address the fact that the defendant had seen and had 3 lawyers at least make contact with your client.
They didn't specifically address that, but they found that those facts did not show excusable neglect. The trial court found that those facts did not show excusable neglect.
Well, how do we know that? I mean, I guess the trial court said he found no excusable neglect.
That's correct.
And so we're to infer that he found that the defendant contacting 3 different lawyers and having 3 different lawyers at least make some kind of contact with the plaintiff, that's not sufficient to rise the level of excusable neglect if no answer gets filed.
That's correct. That was the argument that we presented to the court. So, to move on.
Excuse me for
Oh, sorry,
interrupting,
yes.
but to follow up,
Yes.
so are you saying that that was an implicit finding by the trial court? Or were there explicit findings of fact with regard to its determination that there was not excusable neglect?
Well, the court's order says that it did not find excusable neglect, that the defendants failed to show excusable neglect. It didn't say the reasons why.
Thank you.
The court entered the order denying the motion to set aside on August 12th of 2021. Defense counsel claimed they did not receive a copy of the order on August 13th, 2021, and rather than check the docket to see if any order had been entered, on September 10th, 2021, defendant's counsel emailed plaintiff's counsel to see if an order denying the motion to set aside had been entered, and also the court had orally denied the motion to set aside at the hearing on July 29th, and plaintiff's counsel confirmed that the order had been entered. So that was on September 10th. The deadline for the defendant to appeal the order denying the motion to set aside was September 11th, 2021. So on September 10th, when I advised defendant's counsel that the court had entered the order denying the motion to set aside, they still had time to file an appeal at that time, but they failed to do so. Counsel stated in the appellant's brief, they state that they were not aware that the order had been entered denying the motion to set aside until 32 days after the order was entered, and that is incorrect. The order contained a certificate of service that was signed by the clerk, indicating that service of the order was made on both parties through their counsel. Certificates of service are prima facie evidence of service having been made. So, Your Honors, I would cite you to the case of Discover Bank versus Morgan, which is cited in our brief, and State versus Jordan, which state that the standard of review on a motion to set aside a final judgment is abuse of discretion. As the court knows, the standard is excusable neglect under Rule 60. The defendants argue by citing to plaintiff's response to their motion to set aside that the trial court seems to apply to clear and convincing standard in denying defendants' motion for default motion to set aside. However, there is no evidence that the trial court applied the clear and convincing standard. Merely it states that no excusable neglect on behalf of defendants exists sufficient to set aside the default judgment. And that's the direct quote from the trial court's order entered on August 12, 2021. So there is simply not any evidence for defendant's supposition that the trial court applied a clear and convincing standard. Rather, the trial court applied the same standard that is set forth in the Supreme Court decision, Henry versus Goins, which is the correct legal standard, which applies the three factors of willfulness, meritorious defense, and lack of prejudice. Further, the defendants did not satisfy the elements requiring the default judgment to be set aside. When a party does not adequately explain delay in filing an answer, that failure to file an answer is willful. It thus is not the product of excusable neglect. And I would cite the court to Discover Bank, which is cited in our brief. And H.G. Hill versus Remax, which stated that failure to adequately explain delay in answering indicates that the failure to do so was willful. If the court finds that the defendant acted willfully in the conduct participating in the default, then no other factors need to be considered. And that's what the court said in the Discover Bank case. In addition, a party seeking to set aside a judgment must demonstrate a meritorious defense that goes beyond a mere conclusory statement. Here, the defendant's default was willful because even taking the Schubert affidavit at face value, the defendants do not adequately explain or fail to file any answer until at least 33 minutes prior to the hearing on plaintiff's motion for default judgment. And I would cite the court to Lavonda K. versus Lowe's. It's a 2001 Westlaw 2561-59. As I have stated, a failure to understand the law is not a basis for excusable neglect. And I would cite the court to McBride versus Webb, which is 2007 Westlaw 2790681 at 3, Tennessee Court of Appeals case 2007, wherein the court said that the defendant read the summons and did nothing to respond to complaint as directed by the summons. This is willful conduct. Further, her excuse that she did not understand the language of the summons or that she is not versed in the laws without merit. It is well established that ignorance of the law is not excusable neglect or a proper ground for relief under Rule 60. Moreover, Mr. Schubert's affidavit says that he was not advised by attorneys to file an answer. However, attorney negligence is also does not constitute excusable neglect. And I would cite the court to the Looper case, which is cited in our brief. I think, contrary to appellant's counsel's assertions that the Looper case is similar to this case, the facts are similar that In Looper, the defendant had consulted attorneys, or actually had retained an attorney prior to being in default, but fired that attorney, and then consulted with additional attorneys after that, and then only hired another attorney when he was just prior to the hearing on the motion for default. So I actually think the Looper case is instructive and very similar to this case. The Henry versus Going case, which the defendants rely, I think is distinguishable because in that case, the trial court had dismissed a pending case with no warning whatsoever to the parties in the matter. And that was the basis on which the court reversed the decision of the trial court. In addition, the defendants seek to distinguish Looper by citing to the Abercrombie case to argue that the trial court should not have entered the default judgment against defendants because the answer was filed shortly before the hearing. However, in First Union, the defendant had actually filed a motion to dismiss several months before any motion for default was filed that the court had not adjudicated prior to ruling on the motion for default judgment. And then the defendant only later filed an answer out of abundance of caution. So there was a defensive pleading that had been filed in the Abercrombie case, and that is not the facts in this case. Moreover, even the defendants also do not have a meritorious...
Counsel, you use your time.
I'm out of time. Thank you.
Thank you. We'll hear from the appellant in rebuttal.
Just briefly, the court asked the question regarding the findings the trial judge made in the order on the motion to set aside. I would submit that's kind of the issue of exactly why we're here. We don't know what the trial court relied on or whether it even applied the correct standard in denying the motion to set aside. It just made a blanket statement in the order that there was no excusable neglect. And the reason I say that is because at the trial court level, and again in the appellee's brief, they mentioned the Myers case. And in that case, the language relied on for the Myers case stated, and it's Myers v. Myers, 891 Southwest 2nd, 216, and the site is 220. And the language pulled from that case states that the defendants bear the burden of producing clear and convincing evidence to support a motion to set aside a judgment. In that case, the court was dealing with an attempt to set aside a deed. And the case stemmed from a divorce proceeding, and the case very in black and white, in its opinion, said that in an attempt to set aside a deed, they have to provide clear and convincing evidence. I would submit that that's not the standard for a typical motion to dismiss. We've briefed the standard for a motion to set aside. We've briefed the standard for a motion to set aside. I know that the court is well aware of it, but I would submit that that was the defense cited to the trial court, and we have no idea what the trial court relied on. To use the term in counsel's argument, and it might have come from the court, I guess we are to infer that maybe the court did apply that standard because he denied the motion to set aside and agreed with plaintiff's counsel, or the appellee's counsel at the trial court level. So we would request that the court overturn and remand for further proceedings at the trial court level to allow this matter to proceed on the merits as with preference by the courts. And unless the court has any other questions, I know I have a few minutes left. That's all that I have on rebuttal.
I hear none.
Thank you.
Of course, thanks to counsel for both sides. We appreciate your briefs and your oral argument today. Thank you.
Thank you.
Call the next case.